founding partner at Whitten Lublin, David Swake, professor of organizational behavior and HR management at U of T's Rotman School of Management, and Andrew Caldwell, advisory team lead at Peninsula Canada, an HR consulting and health and safety firm. Gentlemen, I think I heard all the workers of Ontario shut off their phones just now and ignore their emails hearing this. But let's break this down. Daniel, I'm going to start with you. So the way this act works is that employers have to have guidelines for their employees for disconnecting from work. But if the employer is making the guidelines, I mean, I don't know, does that quite benefit the worker? I mean, in a non-unionized environment, do workers have any say?
Thanks so much for having me this evening. And first, I should tell you, and it's important to specify, that this law applies to workplaces with more than 25 individuals. So small workplaces will be exempted. It's the large workplaces that really come into focus. What the legislation requires is a policy, and it doesn't go into more detail than that, and that is probably deliberate given this government. It will require employers to prepare a policy that addresses a right to disconnect, but it doesn't really say what that policy has to say, which is the confusing element of it. It does fall into the anti-reprisal provisions of the Act. So arguably, if there is a policy and if someone is penalized or disciplined when they have the right to disconnect, one could make a complaint to the Ministry of Labour under the reprisal provisions that exist.
Okay, so as you noted, this is quite vague. And David, as a professor of organizational behavior and HR management, first I want to touch on that note. I mean, the Ford government, as Premier Ford has said time and time again, Ontario is open for business. Well, sounds like there's someone closed for business after hours for their workers. Daniel's noting this sounds intentionally vague. Does that surprise you in any way? And I mean, how can this even be enforced?
Well, you know, it's an interesting policy in and of itself, and it really speaks to where we are, where everyone is so burnt out through COVID, through everything, where we need to have a policy like this. And, you know, it could be useful, but the proof is really in how it's implemented. So, you know, unless there's like a wholesale adoption of this, you know, right from the top of the organization, where you have an organizational culture that embraces this idea that after work, we all turn off. And nothing is, you know, so urgent that it needs to be handled after work, this isn't going to work, and it's going to be very difficult to enforce. So until you get it down to the level of, you know, managers and leaders who are really, you know, who might actually enact this kind of change and enforce this, unless that happens, this isn't going to do anything at all.
Mm-hmm. And Daniel, what kind of penalties would be in place anyhow? I mean, if the guidelines are so vague, an employer could just say, look, after work, for about 2 or 3 hours after work, I'm able to contact you and you must reply, or there's consequences. I mean, how does this fall into play in terms of enforcement, consequences for bad actors in terms of employers or even employees?
Well, first, I think the intention here is that there's transparency. That's really probably what the goal of the legislation is to create a model where there's transparency, where individuals know what their working hours are and whether or not they'll be paid overtime if they have to connect and work in the evening. In terms of how you enforce that, it's actually quite simple. If someone fears that they've been retaliated against when the policy or when they challenge the policy, for example, if someone's asked to work in the evening and says, no, you know, I have other obligations, I have to watch my children or whatever it is, and they feel like they're disciplined or even potentially dismissed, you have the right to file a very powerful complaint to the Ministry of Labour, which then conducts a free investigation and essentially can order an employer to reinstate an employee or to award general damages for bad actors. So there is teeth if someone can make a successful complaint to the Ministry of Labour.
Okay, that adds some clarity. Andrew, I want to bring you in. You are an advisory team lead with Peninsula Canada, and one of the questions off the top we asked is this: good for workers but bad for business. Now, what Peninsula does is, you're a firm where if someone is a small business, or even if they're a business with, let's say, 27 workers, which this act applies to, they don't have an HR department or a legal department. They hire your firm. What kind of questions are you getting? And is this good for workers, bad for business?
Well, thanks for having me, and it's an honor to be here and hear the differing opinions there. And it's true, there is some merit to this and why it's been run out, but I think there's also some things that we need to think about of the timing of this and when it was rolled out. But in terms of how it's affecting the small to medium-sized businesses, it's just like most changes that have come out. We've seen more changes to employment standards than we have probably in the last decade and over the last 4 years. partially due to COVID, but predominantly prior to Win coming in and then Ford taking over. So a lot of these have really rocked the bed of small to medium-sized businesses, and they don't know what they don't know. And so that confusion is really what's setting in here. And so these vague rules that have been set up have really created an uncertainty to small businesses. As you said, those who may have 25, hire a new one. You're now at 26. This is going to apply to you. Do you have that policy ready to go? So how it's good for business is the sense that there is some transparency. You know when you can have your workers working, when they can't have them working. You need a system to make sure you're tracking that accordingly. Just as Daniel said, you do not want to fall on the wrong side of this and get hit with any type of fine, because they just have to make the implication that there's a reprisal against them, and they could probably make a good case against the business if they don't have this policy.
So, Andrew, so I was going to say, in terms of some of your clients, at least there's some guidelines, a rule book for everyone to play by. You could say, look, and the Act says between January and March 1st of each year, an employer must ensure it has a written policy in place for all employees with respect to disconnecting from work. So a frustrated employer who calls you and says, what am I going to do from an HR perspective? I need someone to come in. They shut off their phone after hours. This creates a bit of a rule book.
Correct. It creates a bit of a rule book, but it also creates a way for the employer to start enforcing the policies and making sure that people are productive while at work. And we can kind of start to limit overtime as well. So there's some benefits to the employer from having this, but it's how do you apply it, how do you use it? And that's where you need, an individual like myself who can think outside of it and not be emotionally connected to the business. Say, let's look at the positives of how we can use this.
I have so many questions for all three of you, but with the time we have left, David, I'm going to turn to you. This non-compete clause that's been banned. So non-compete for people at home means you have something in your contract saying you can't go work for a competitor within, let's say, 1 month or 3 months of quitting from our business. These are banned. Is that not bad for business?
I don't know if it's bad for business. It depends on the perspective you take, whether it's good for employees who don't want to get shackled to an employer and afraid to leave or leave a bad situation and can choose to move on. And it might force employers to treat their employees better while they're still working for them. The thing with the issue with this new policy around not connecting after work is, whether or not it gets enforced, whether or not people, decide that they can make a legal challenge to it if it's abused, what it might do and what it might begin to do is to get rid of this silly idea of, we have, this idea of this culture where, everyone works really long hours, everyone works, pitches in, does everything for everyone, and we don't have enough resources and we don't have enough organization to get our work done within the workday. The hustle culture. Mm-hmm. And that's got to go away because that is really toxic. So to the extent that this new legislation might help get rid of that idea of that hustle culture as being acceptable, maybe that's a good thing.
Gentlemen, thank you so much. This is a topic we will continue to explore. Not to mention, we spoke about a survey tonight in which people they want to quit their jobs because of one reason is a lack of work-life balance. So this is something we'll continue to explore in the coming months. Thank you all three for your time and your expertise.